Sacramento. Welcome to Money 105.5, the Wall Street Business Network. This is All Things Legal. My name is Craig Ashton with the law firm of Ashton Price, and this is where curious personal injury attorneys distill topical events into their legal essence. This morning I'm joined by my colleague Tim Hodson.
Morning, good to be here.
Edward Schade.
Morning, Sacramento.
And we're happy that you're joining us. So let's kind of break down. We're calling this the Denise rule, which I like, man. This is about getting to the point.
Here comes my text.
And Denise is Edward Shady's beautiful wife, and she is now a shady lady.
That's true.
According to the license plate, yes.
But anyway, so taking that suggestion, which was constructive criticism, and using it to better the show, our lives, your lives, and the entertainment content, plus the intellectual acumen that is being streamed at you in real time to improve your Jeopardy game, let's begin by talking about what we'll speak about today. We have a Bay Area lawmaker, and his name is Jerry Hill. He's from San Mateo. And he, with Mothers Against Drunk Driving, are proposing blanket legislation, which would make it mandatory that anybody who is convicted of a DUI in California to have a ignition interlock device on their car for 6 months. So we'll talk about that, whether or not that's a good idea, how that works, whether or not that's an invasion of privacy, how police power works, etc. We can even throw in the 10th Amendment of the federal Constitution that allows the states to exercise rights that are not prohibited or restricted under the federal Constitution. We can talk about that. We'll go ahead and talk about our friend Nick Young and the Lakers. We're from Sacramento. So it's always nice when you can kind of, dig at the Lakers a bit.
Throw some shade on them, yes.
Yeah, throw some shade, as they say. Edward Shady, you should know.
Oh, absolutely.
You're the original Shade.
You can look at their record this year. That's enough.
Yep.
So we've got Iggy Azalea, who is from Mullumbimby, New South Wales in Australia. And ultimately, she is a rapper who comes across as though she grew up in the streets of Atlanta with a kind of an African-American kind of street thing going on, even though she's a light-skinned Australian. She is engaged to be married to Nick Young for the Lakers, who likes to be called Swaggy P.
Yes. Self-given, by the way.
And then we've got the first-round draft pick of the Lakers last year, D'Angelo Russell, to help kind of take the team in a new direction because Kobe Bryant is retiring. Well, it's all going wrong for the Lakers. And we've got essentially an invasion of privacy issue. We've got a Penal Code 632 violation of a private conversation that's now gone on the internet, which is calling into question Iggy Azalea's nuptials to Swaggy P within the confines of the Lakers. So we'll talk about the legal issues associated with that, and we're going to give some new nicknames because you're going to be Timmy FP.
No, we're not.
You're going to be Eddie.
I'll just keep talking so nobody hears
CG.
Cabeza Grande.
I'll be Craigie C, right?
I'd rather be the Oracle of Orange County.
So that's Timmy Fast Pitch. That's Eddie Cabeza Grande, based upon his intellectual acumen and the fact that your melon is very large. And I learned this as a result of you not being able to fit into a tri-helmet that I gave you.
That or you're a pinhead.
Might be a combination of both.
And Timmy FP is fast pitch baseball, right? So he can call himself Swaggy P. All right. All right, then we'll go ahead and break into William Shatner, who's claimed biological son is going where no man has gone before, suing William Shatner for $170 million for slander, defamation, and libel. This individual, his name is Peter Sloan, indicates that his mother got pregnant. Her name was Kathy McNeil. She was an actress during a tryst in Toronto, Canada.
Which is funny, Peter Sloan, because I just remember, the Matthew Broderick movie, Ferris Bueller's Days Off. His girlfriend's name was
Sloan
Peterson.
Right. That's right.
Oh, Sloan Peterson?
Yeah.
That's right. You're right.
There's Cabeza Grande right there, I'm telling
go.
you. You just never know where that intellectual acumen is going to take us. But
That was
today,
just trivia.
a little bit of trivia, and then you might take us into Greek mythology and Sisyphus.
There you go.
And actually listening to you is Sisyphusian because it's almost like repeating the same intellectual brilliance over and over.
No?
Just keep pushing that rock up the hill.
Yeah, no kidding.
All right, so we'll talk about William Shatner. We'll talk about $170 million cause of action for libel and slander. And within the confines of what's gone on with Hulk Hogan, what happened with Aaron Andrews. I mean, it turns out that if you're a star and you're suing,
It's going to
then
go well for you.
chances are that you're going to get a big payday because the jury's going to like you.
But this is the opposite.
This
'cause
is the
Shatner's
opposite.
star here, yeah.
But not in the Swaggy P case, because Swaggy P could be the plaintiff. And depending on how people feel about Nick Young, that case could go, in the same direction as an invasion of privacy case. So we'll talk about that one. We'll talk about William Shatner. Hey, we'll talk about Donald Trump.
Who
Corey
jumped the shark this week.
Yeah, so we're not going to talk about his ideas about the right to privacy under the Fourth Amendment, which was codified or at least judicially decided in Roe v. Wade to say that a woman has a right to choose based upon her Fourth Amendment rights to her right to privacy in her reproductive decisions, and therefore the government cannot intervene, at least within the first 2 trimesters. The third trimester, there is an issue as to whether or not the individual growing in their body has rights to be protected under the Constitution. That's why the restrictions. We're not going to talk about that and the Fourth Amendment and all the intellectual ideas associated with the statement that Donald Trump made. What we're going to talk about is Corey Lewandowski, who is his
Lewandowski.
Lewandowski. That's right, because he might be Polish, right?
Oh, that is guaranteed Polish. That's my wife's grandparents' last name.
So Timmy, tell us about the your wife's family's Polish.
Yes, her last name is Korzeniewski, and then Lewandowski is the other last name of her family. So that is Polish, yes. And you guys know I don't really follow politics. I told my wife yesterday I was reading the story. Did you know that Trump's campaign manager is Polish? She's like, where have you been? I just don't follow this stuff. So.
You got to give him a nickname, the Big Lewandowski.
Yeah, the big.
That's a little bit too much honesty for our listeners who are looking at the direction.
Not me. Political direction. Don't look to me, man.
That's what we like about Timmy FP, man. He's very honest. All right, so basically with Lewandowski.
Yeah,
Lewandowski.
Yeah.
Okay, Lewandowski. Ultimately, he grabbed the arm of a Michelle Fields who worked for Breitbart, and she basically quit or was fired. She claimed there was assault and battery. There's a video showing what occurred, and we'll talk about battery. Finally, they're calling it battery because usually they call it assault.
Right.
This is a harmful or offensive touching rather than the apprehension of harmful or offensive touching. So an assault is somebody's about ready to punch you in the face.
And you get scared.
And the battery is actually being punched in the face. So the idea is when you look at that video, I'm looking at it, and it's not only a subjective harmful or offensive, but it's an objective, a reasonable person's standard. And with the confines of what's going on in our criminal system, I don't know if that video would be enough for a jury to convict this guy of misdemeanor battery. We'll see. We'll talk about that. Then we'll talk about this new law that's being proposed in New Jersey where you could be fined $50 or spend 15 days in jail.
15 days
Wow.
in jail.
Quote, if a person on the road, whether walking or driving, presents a risk to others on the road, there should be a law in place to dissuade and penalize risky behavior. And that is ultimately, if you're walking and texting, then you could be fined or put in jail for 15 days. That's a little draconian.
Yeah.
But, it probably would have its desired effect. So we'll talk about that law. That doesn't apply in California. We'll talk about the law of negligence. Talk about homeowners, if something happens to you while you're doing this and you hurt somebody. And then we'll talk about what the real rules are and laws are in California for cell phones, handheld devices, etc. And we'll do that as the show progresses. So let's go ahead and begin, before we take the break, of kind of breaking down what's going on with this new proposal for a blanket rule in all counties for anybody convicted of drunk driving, 0.08 or more, to have a ignition interlock device put on your vehicle for 6 months, which you are required to blow into, and then while the car is being driven, periodically you have to blow again, which basically will stop you from driving to a bar, leaving your car going, and then getting back in the vehicle, right? So you have periodic times where you have to blow. Right now, the 4 counties that there was a test was in Sacramento, L.A., Tulare, and Alameda, so that was already in effect in Sacramento County.
Since 2010, yes.
And now in most of the counties, it's 0.15 or more. The judge is going to order that to be put on your vehicle.
Correct. And if it's your second or third offense, it's guaranteed as well.
Right. So, Tim, you do DUI defense in our office, and you used to work in the public defender's office. So you understand the criminal issues. So I just got a sign from OG, our producer, that we're going to take a break. So when we come back, we'll go ahead and talk about the new rules being proposed for interlocking devices on your vehicle, and then we'll ask Tim about his opinion on it. This is All Things Legal. I'm Craig Ashton, and we'll see you after the break. All right, we're back. I like that song.
I do too.
This is Craig Ashton, shows All Things Legal on Money 105.5, the Wall Street Business Network. This This is where curious personal injury attorneys distill topical events into their legal essence. And we're looking out here on the 5th floor of the Northwestern building in the Arden area. And I got to tell you, what a beautiful place we live in. And that song just makes me want to walk out on the show right now and go ride my bike.
Right, Tim, Tim is the new host today.
I don't ride bikes, so I guess I'm doing this by myself today.
All right, so before we took the break, we indicated we were going to break down for you this new proposal. So Mothers Against Drunk Driving and Jerry Hill from San Mateo are proposing that our legislature pass a law that will apply to all the counties in California to say, regardless of the number of times you've been convicted or the amount of alcohol in your system, as long as you're convicted of DUI, that for 6 months you'll have an interlocking ignition device on your vehicle that you'll have to blow in periodically while you're driving your vehicle to show that you are not under the influence of alcohol. And Mothers Against Drunk Driving said, look, this is not punitive. This is basically just to allow people to go to and from work. This is not meant to be punishment. It's just basically recognizing that we want people to be productive. Drinking and driving is a bad thing, but we shouldn't impact your ability to support your family. And I think this is a good idea. I personally support this 100%. And if you really wanted to stop DUI, right, you would just put these devices on every vehicle, like the new technology we're going to have for driverless vehicles. Your car, if it's driverless, is not going to be driving under the influence of alcohol, right? If it's, a Google vehicle. Hopefully. So you put, if you make it mandatory in every vehicle that there's an interlocking device that you have to blow into before you get in the car, will not start if you have any alcohol in your system or over 0.08, that would stop drunk driving in a heartbeat. But guess what? You know who's going to be against that? Budweiser, the Restaurants Association. People, private citizens want to have a barbecue. And then everybody there will be stuck at their house for the entire weekend.
You ain't got to go home, but you got to get out of here.
Yeah. So the point, or be very good for Uber and Lyft, and they would probably be behind it. Their taxi association. So the idea is that we could solve drunk driving tomorrow with a blanket law in California that says every car that is manufactured and sold in California requires an interlocking ignition device to say that if you're drinking, your car will not start.
You would take a lot of money out of a lot of pockets if you did that. Those
or you could revert right back to the 20s and just call it prohibition.
Right.
So this particular proposal is more circumspect in its application, but it says that, hey, if you get a DUI for 6 months, you can go to and from work, but you got to blow into your interlocking device. And ultimately, you got to do it periodically so the car can verify. And then that information gets sent to law enforcement, right?
What's the readings?
Yeah.
The readings, no. The readings don't. The car won't start. If you blow into it and you have any measurable amount of alcohol in your system, the car just either won't start or it'll start to gear down. If you're driving, it'll pull over. It's weird, man. It starts to gear down on you. It'll stop. I mean, it'll literally stop.
So to give you a quick background, for me, I started practicing law in San Francisco about 24 years ago, and I've done personal injury only for that time. Ed, you were in Orange County. You've done some criminal defense.
Correct.
Last case you tried in Southern California was a DUI case, right?
No, that was the last criminal case I tried.
Case, okay.
Down south.
And you got your person acquitted.
Yeah, I got an acquittal, actually.
And how did that happen?
My client was smart enough because it was his third DUI, not to do a field sobriety test and or engage in the alcohol test or the chemical test at the time. So it was a straight. They had to prove by presumption, and they weren't able to do it. And the nice thing was that the officer who did the investigation had two other names in the report that weren't my client.
Slam dunk right there. Slam dunk.
So why don't you explain to the listeners, because Tim, you were in the public defender's office.
Yes, part of being an intern in the public defender's office is you basically have to run impossible motions, which are called pitches motions and 1538 motions. And in essence, you're trying to get your client off on basically a loophole. Either something's wrong with the police report or something's wrong with probable cause. And it's human nature because the cops they're overworked.
So sometimes they cut and paste. And
oftentimes they cut and paste reports, and it's just
the wrong names in there, which says calls into question their credibility.
So there's two names in the reports. And to their credit, they'll admit it under oath. Like I don't know what report I'm referring to. If there's two different names, and they'll admit it under oath. They don't go around it. So
because with regard to the field sobriety test, you go, well, who stepped off the line? Was it Mr. Ashton or was it Mr. Hodson?
Right. No. So that's the way you get them. That's the way you get cases off on bad police reports. And it does happen. And they, like I said, to their credit, the cops I did cut and paste this. I can't tell you which report I'm referring to.
But most of our listening audience doesn't understand that DUI is a two-track system because you also have a proceeding through the DMV. In addition to the court, you can win at court, lose at the DMV, or win at
vice versa.
Or vice versa. I mean, I actually had to bring a writ against the DMV years ago because they took my client's license away. They didn't have it's a per se statute. And the Orange County Crime Lab at the time was calibrating their own breathalyzers, and they weren't licensed to do so. And once I proved that, then they had to bring in Marty Breen, who was the head of the crime lab at the time, to testify that it was all done properly, and they never did it. So then I asked for a review. They said no. Then I filed a writ. The court agreed with me and then ordered the State of California Department of Motor Vehicles to pay all my attorney's fees and return my client's license.
Sounds about right for Ed Schade right there. Sounds about right.
Yeah,
But just to add to that, so and kind of where Ed's going, so it is a two-tier system, but basically in Northern California, if you get pulled over and get convicted of a DUI, it's about a 99.9% chance whether you blow a .08 or .3 that a judge is going to order the ignition interlock device in your car. We do a lot of DUIs in Sacramento, Yolo, El Dorado, Placer County, and as of the first of this year, every judge is pretty much ordering it. It's a DA's recommendation, and the judges are going forward with it. So that's the bit. When every time someone calls me and asks me what their charges are going to be, what their sentencing is going to be, when I tell them they need to get the ignition
and
interlock
the defendant has
device
to
in your
pay
car,
for it, right?
and they have to pay for it. You have to get an SR22 from DMV to give them the permission to drive with the ignition interlock device, and you have to get it installed. You have to get it calibrated every 2 months. It's a pain and it's expensive, and that from all the people that is the biggest deterrent afterwards. Is like, I never want to have that in my car again.
What's funny is when you started practicing law, Tim, it was .08, and it always has been under 23-152B. But when Craig and I first started practicing, it was .1, and it keeps going down. I don't know where it's going to end because they're pushing for what, .05?
Yep. There's a huge lobby in Placer County right now to push it to .05.
And how can you say that .05 is per se under the influence?
That's where you have to go.
If under the current law, they're right now have already legislated that it's not.
Well, the way that this could be tested, because we're going to have technology going forward where you can actually take a driving test on the side of the road, because everybody reacts differently. For instance, Swaggy P, who we'll be talking about, is a better athlete than I am, right?
No.
So
he can shoot, man. The kid can't shoot.
So the point
I don't
is,
think he can do a triathlon.
Some people have higher, skill sets when it comes to hand-eye coordination, where a .08 for them may not basically make them dangerous to drive a vehicle versus somebody else who doesn't have the same genetic gift to be hand-eye coordinated advanced. So we could test those things at some point, because right now it's just a blanket rule which says everybody one size fits all, which is really not the case.
Yeah.
And there are pretty significant consequences for getting a DUI, and it's very expensive. There's a stigma, etc., and causes all kinds of consternation in your life. And at the end of the day, it may not always be fairly basically applied, because just because you're .08 doesn't necessarily mean you cannot safely drive a vehicle. It just means the law says you
And that's
can.
supposed to be the point of the FSTs, but
Yeah.
those are almost impossible to pass if you're sober.
Field sobriety test.
Yeah, so the way it goes is that the cops can pull you over if they have a reasonable suspicion.
Right, probable
and then
cause.
probable cause is when they arrest you, and then you have to have beyond a reasonable doubt to be convicted.
Correct.
All right, so that should help your Jeopardy game. Let's get into something a little bit less important from a sociological perspective, but more satisfying from a purely
Entertainment
perspective, which also has a legal foundation, which
And
fits
some
into
cool
the
names.
show, right?
Absolutely.
That's what we do here. So let's talk about Iggy Azalea, who is a Australian-born rapper who comes across as though she grew up in the streets of Atlanta. She's from Mullumbimby, New South Wales. Her dad was an artist and her mom was a house cleaner, and apparently her roots in Australia go back 100 years, and she claims to have some Aboriginal roots. She decided to go on a walkabout when she was 16, and that's the Aboriginal term for actually going out and finding yourself in the
And she ran down. She
in the
ran in.
outback.
She ended up in Atlanta on that walkabout.
Well,
Yeah.
she ended up in Miami, I think, and then ultimately got hooked up with a producer.
T.I.
And now she sounds, if you hear her rap, ultimately she kind of sounds like she grew up in the streets of the South somewhere, rapping some pretty aggressive, lyrics, right? Even though she's from Mullumbimby, New South Wales.
That's a great town, by the way, people.
So Nick Young, who went to USC, who, as you know, I went to Cal. None of us here, except for Coach Phil, who's not here, have any sort of affinity for USC. So it's always great when we can make fun of people from USC. Now, if you are a USC graduate or have an affiliation with USC, hey, the reason we can make fun of it is USC is a great school. But what happens is when you have 42 Nobel Prize winners associated with Cal, but you get your butt whipped on national TV constantly in sports, it becomes a sore point in a man's life. I can only watch your cheerleaders, male wearing very, sporty sweaters doing push-ups so many times, and it's indelibly inked
Well,
in
your
my mind.
cheerleaders can't because they have those hefty, weighty medals from the Nobel Prizes.
Yeah, and their brains are so large. All right, so anyway, Nick Young went to USC, now plays for the Lakers, who, I grew up in the Bay Area, been in Sacramento now for 20 years. I'm not a Lakers fan. And ultimately, he goes by Swaggy P, and he's going to marry Iggy Azalea. D'Angelo Russell was a number one pick second in the draft?
So, yeah, number 2 overall pick.
Number 2 overall pick for the Lakers
Ohio
to
State.
recalibrate the Lakers' future without Kobe Bryant.
Yes.
Well, guess what?
It didn't.
Swaggy P's in bed. He's about ready to marry Iggy Azalea. So D'Angelo Russell thought it would be a good idea to ask him questions. So tell me about these women you've been sleeping with. And how old were you when you slept with them? Oh, you were 30 and she was 19, which allows Iggy Azalea, who's a very smart Australian.
To do some math.
Yeah, I don't think they have, Common Core in Australia?
Yeah.
So, yeah, she
Who
just was
knows?
able to subtract 30 from 19 and come up with a number, right? So, anyway, which is 11.
Not in a common core tonight.
So she knows that Swaggy P has been 30 with her, and if Swaggy P is talking about sleeping with a 19-year-old while he's 30, she knows that they were together at that time. So that is not a good thing for Swaggy P.
No.
So the problem is that California Penal Code 632 says, look, California is a 2-person consent state. So anytime you have a private conversation, and this conversation was taking place, it looked like in a bedroom with D'Angelo Russell was on the ground, the perspective from where he was videotaping it. Swaggy P's lying down, D'Angelo Russell's on the ground. Asked him, did you sleep with her? He said, what about Amber Rose,
Right.
who's, I think, Kanye West's old girlfriend?
Yeah, she's a model.
You ever tried her? He was like, they're talking about it like they're commodities, first of all. So, and then second of all, basically getting him to admit that he'd been sleeping with other women. So that's clearly a violation of penal code, plus it's invasion of privacy civilly, right? And we also could have a contract issue here. So when we come back, we'll talk about Swaggy P. We'll get Timmy FP's and Eddie CG's opinion about Swaggy P, and we'll do that after the break. We'll talk about privacy and contract. This is Craig Ashton, All Things Legal. All right, we're back. This is Craig Ashton on Money 105.5 and the Wall Street Business Network. The show is All Things Legal. You're sitting here with 3/5 of the lawyer brain trust of Ashton Price, personal injury law firm, but we are curious personal injury attorneys. We distill topical events into their legal essence, and today is no different. Hopefully you find it entertaining. At the very least, it'll help your Jeopardy game. And before we took the break, we were talking about the mess, which is the LA Lakers, which is always fun to talk about if you feel an affinity to NorCal. I was basically raised, was born in South Africa, and that's as south as I get. So Southern California was taken out of my affinity early on when I moved with my family to Redwood Shores, which we were like one of the first 4 houses there. Now it's got Oracle and everything else. Went to Sarah High School, Barry Bonds, the same place that Tom Brady went. Went to Berkeley, grew up in the Bay Area, lived in Sacramento now for about 20 years. So this is where I call home. This is where I feel comfortable, and the Lakers are not part of my daily regimen in regards to entertainment value, unless, of course, they're acting like idiots, which they appearing to do now.
Make it very easy, yes.
So here's what we got. Kobe Bryant's retiring. They just got beaten by 48 points against, was it Utah?
Utah, yes.
Oh, my God.
48 points. So instead of the farewell tour that Kobe was looking for, they have the second worst record in the NBA.
Yes.
He's going out with a whimper. And ultimately, the only reason we're paying attention to the Lakers now is because of a faux rapper from Mullumbimby, New South Wales, who comes across as though she may be raised in the streets of Atlanta, even though she's born and raised in Australia. And we've got Nick Young, who basically has given himself his own moniker of Swaggy P, even though from what I can tell, I don't think he's of the upper echelon of NBA player.
No, he's not even close.
And D'Angelo Russell, who was their number 2 pick, which turned out kind of to be a bustish, right?
Well, yeah, considering what Porzingis is doing for the Knicks, that's who they
So
probably should
yeah, I
draft.
mean, if the Lakers have the second worst record in the NBA, and he's their point guard.
He's a solid player, though. I mean, he's not like he's terrible, but
So he was able to get Swaggy P to admit on a surreptitiously recorded cell phone video that he had slept with a woman recently within the confines of the quasi contract, which is would you marry me? So he is engaged to Iggy Azalea, and ultimately that doesn't go well. I don't care what country you're from or where you purport to be from, right? So she's saying, hey, that's not cool. And so the Lakers are saying that's not cool either, because guess what? We're supposed to be a team. What are you doing videotaping?
Didn't this save the Kardashian marriage with the guy out there in Nevada?
Yeah.
So
Yeah,
maybe
true.
he thought another NBA player.
You talking about Lamar Odom? Yeah.
Maybe.
Yeah, so Lamar Odom just got out of brain damage.
It only worked for Lamar, not you, Swaggy P.
That guy is Lamar Odom. I mean, he's the original gangster. If he basically goes into a coma in a brothel with cocaine and alcohol,
And saves
doesn't
his
get
marriage.
divorced, it saves his marriage, and now he's drinking on the night before Easter after he has brain damage from overdosing.
Yeah.
Holy moly.
Holy moly is right.
Swaggy P, that is not the role model.
No, do not follow those footsteps.
So let's get to the legal issues, although it's very difficult with these crazy idiots. So anyway, the legal issues are basically California's a two-party state. So when you're on the phone and you hear it beeping, that is enough to let you know that the conversation is being recorded.
Yep, that's
So
simple.
when it goes beep, and if it's continuous, then at that point you're on notice that it's being recorded, and therefore you can't say that there's an invasion of privacy. That's why when you go online, let's say with an insurance company, you go on the phone, they say, please know that this is being recorded for
Training purposes.
Training purposes.
Quote
Yeah,
unquote, training
exactly.
purposes.
And I usually say my voice is very melodious and can tape away.
I always say, so all the stuff you said before you told me that, it's not going to be on here.
Yeah.
Yeah, and then if the conversation doesn't go well, and I tell them that reason is not a currency in which they trade, and perhaps they are a confused cartographer and they believe the Earth is flat, and
It's not.
suggesting to them that they ultimately what they've uttered certainly cannot be believed, because I won't challenge their intellectualism to suggest that they believe that which they just uttered.
I've heard you say that many times.
And
I
then,
laugh every
then I
time.
say, go ahead and play that back for your supervisor,
Yeah.
because that might be instructive, because perhaps you're better suited for retail.
I've heard you say that many times.
So anyway, when it's being recorded, you can use it to your advantage if the point is right, because merit works. In this particular case, illegally videotape this because it doesn't appear as though there's consent. It's not clear whether or not this is in California, so it could be in a different state, so this wouldn't apply. But if it did occur in California, then this could be a misdemeanor, which is the same thing we had in the Donald Sterling case, where he was telling his putative girlfriend, who was African-American, not to hang out with African-Americans, which then called into question whether or not he was in the best interest of the NBA, which is a contract issue. His wife said, hey, you're 80. Let's go ahead and go to Vegas, and for your birthday, we'll get you a couple neurologists to determine that you're incompetent. And so he says, I'm not incompetent, and gets Steve Ballmer, who is the worst CEO in the country, according to Forbes, to pay $2 billion for the Clippers.
Yep.
So that's how that ended up. So Swaggy P may become a billionaire after this is all over, right? So the point is that this is a violation of the penal code. It's an invasion of privacy. We already saw what happened with Aaron Andrews and then Hulk Hogan, where somebody surreptitiously videotaped them. In Hulk Hogan's case, he was having sex with Bubba the Love Sponge's wife.
God, you can't make this stuff up.
Oh, my God.
And that got on the internet, and he got $140 million for his trouble. And then Aaron Andrews was surreptitiously videotaped by a quote-unquote stalker. Somebody was enamored by her, found out what room she was in, looked through the peephole, videotaped that, naked, got on the internet. She got $55 million. So, Swaggy P could sue D'Angelo Russell, and this gets in front of a jury. And if they are a Lakers-friendly jury and they like Swaggy P and Iggy Azalea, right? I mean, he could say, look, this injured me. I'm losing my fiance's gone. It impacted my career. Now, he could actually both of them could be terminated from the Lakers if they wanted to. Nick Young could be, because he's basically admitting to cheating on his wife, which is not in the best interest of the Lakers. What D'Angelo Russell did is not in the best interest of the Lakers. And if there's a morality clause, which usually is in their contracts, that they could be a breach of contract and they could be terminated.
Yeah, they could, but if you're going to terminate NBA players' contracts for cheating on their wife on the road.
Well, yeah, but it's on video.
Could be no NBA.
But what about when he stepped up and videotaped it
Right.
and then it got out?
Right.
I mean, who knows how it got out? He probably shared it with his buddies.
I don't think there's any way he purposely meant for this to get out, because there's no way in D'Angelo Russell's world where this could have gone well for him, especially in that locker room. Nobody's going to talk to him, especially for the rest of this season.
How about in the NBA at all?
Right, that's what I'm saying. He's got a long, long road to till before he's trusted by anybody in the National Basketball Association. There's no way he would have meant for this to get out.
I mean, would you do this to any of your friends?
No,
know,
I mean,
No. And
everyone keeps saying guy code. That's not guy code. That's human code. Like, you don't. anyone that's trusting you with confidence and telling you about stuff, and then you record them secretly and then negligently allow someone else to look at it and then release it. I mean, there's so many
He's going to have to
inherent
go back
laws that are bad with that.
He's going to have to go back to wearing a pager
Well,
so that he can't tape anybody.
Yes, I mean,
Perhaps if I was such a tool to call myself Craigie C, and, and made you call me Craigie C, maybe perhaps I get what I get.
Stranger things have happened in the office.
But anyway, the thing is that's illegal. There's invasion of privacy issues. Civilly, the damages would be provable because if Nick Young gets terminated because of this, and he gets terminated by Iggy Azalea because of this, then a jury would have as much to go on as they did with Erin Andrews, who was seen naked but got a promotion and got better jobs and was on Dancing with the Stars. And actually, she did not have a lost income claim at all because she actually made way more money
It was just
after the exposure, right?
It was just emotional
So they gave her $55 million for emotional trauma.
In this instance, I mean, like Swaggy P, maybe got the name, etc., clothing line, but if this starts interfering with any possible endorsements he would have had or extra contracts, commercials, etc., he's got a great cause of action.
But see, the problem is he's a knucklehead. I mean, he has no endorsements. The Lakers have tried to trade him for the last 2 years, and not one team wants him because this kind of stuff pops up. If you remember 2 weeks ago, a lady accused him of sexual harassment and videotaped him on the road, Nick Young. He needs to stay away from the camera. A high-level women's rights activist videotaped him. She said she didn't know he's an NBA player. Come on. I mean, you live in L.A., you don't know who the NBA players are.
He's only 10 feet tall.
But so I mean, he's constantly getting himself. He's constantly getting himself in trouble like this.
Yeah, I thought you were a disc jockey.
Yeah,
but
I thought you were a jockey at the track in Santa Anita.
I mean, I don't know how much. I don't know how much time you want to spend on this, but clearly in his room, Nick Young has expectation of privacy. Now, say this happens in the locker room, would you think you have an expectation of privacy?
Totally, 100%.
Yes, you would say
Absolutely.
yes. Yeah.
But not if there's
there's
a bunch of
reporters
people around.
even though reporters are filming
reporters
you,
around, different.
Right. I mean, which is as soon as the game's over, that would think was like 15 minutes of which is crazy. Those guys get 15 minutes to shower before the media comes in. I mean, I'm not a girl. I don't even have any hair, and I can't take a shower in 15 minutes. I mean, so the fact that they get 15 minutes of privacy before the media comes in, I mean, it's just an interesting topic to think about. If he was in the locker room, is that really a private conversation?
Well, and you know why it's an interesting topic? Because I chose it, and that's why we're speaking about it.
There you go.
But yeah, it is. I mean,
It's axiomatic.
It is axiomatic. Oh, and that is Eddie
SAT
CG.
word right there.
Cabeza Grande.
There you have it.
But yeah, so these are things that you look at, and if you're a Lakers hater, you just basically hate. But there are legal reasons for exposure here, which is criminal, which is a misdemeanor. And then there's civil, which he really could be facing. I mean, if Nick Young, if Iggy Azalea says, I'm out, and she goes on a walkabout without Nick Young, Swaggy P, and Swaggy P gets traded to Philadelphia.
Ugh. Siberia.
Then I would say, and D'Angelo Russell, what's his contract? I mean, how much money is this guy going to make over the course of his career?
The rookie, it's salary capped now, but no, he's probably got like $4 or $5 million this year with outside of his signing bonus.
But I mean, once he gets going, assuming he's a top 10 NBA point guard.
I mean, it's all the NBA is completely structured, so. Yes, he has the potential in 4 years to sign a $70 to $80 million contract. Yes, once his rookie contract is over.
And you know what? I don't know if he's got some sort of personal liability policy, but what could be argued is he intentionally videotaped this.
Clearly.
But negligently it got on to the internet. In other words, he wasn't using reasonable care to protect the information. And then because it goes from an intentional tort to a negligence cause of action, insurance might cover it.
Homeowners, yeah. I mean, if
homeowners, or you might have
a general
liability policy because of
if his agent has any brain in his head, he has a general liability policy. I mean, anytime a kid's worth that much money,
Swaggy P, Ashton Price would be perfectly sorted out to look at this, and I'm familiar with Australia.
Yeah, it would
in fact, I did the Pan Asian Championships for Ironman in Melbourne.
And we have no
my brother
problem
used to live
going
in
after
Sydney.
fellow Lakers since we don't like the Lakers.
And he's from Ohio State, so that's a double whammy. He's Laker and Ohio State. So.
There you have it.
No problem there.
So we would take that case for Swaggy P.
Yes, we would. I would call him Nick Young, though.
Nick Young. Okay. Yes, Mr. P. All right, so let's go ahead and change gears here. And it looks as though Peter Sloan, who is a radio show host in Florida, is going where no man has gone before, which is suing William Shatner for $170 million for defamation and libel. So basically what Peter Sloan is saying is that when his would-be dad was on the set of T.J. Hooker in 1984, he purportedly
A great show.
You can't make this stuff up.
T.J. Hooker was out with a hooker.
That was Ed Schade, for those who would like to know. All right, so a 59-year-old radio host basically says, hey, his mom was Kathy McNeil. She's an actress. And then T.J. Hooker, at the time, William Shatner, decided it would be an interesting experience to have sexual ingress with Kathy McNeil, and ultimately conceived a child, which is Peter Sloan. Peter Sloan is suing William Shatner for defamation and libel because William Shatner is going out of his way to say, you are not my love child, and I have daughters, I don't have any sons, and so he's suing him for $170 million. So when we come back from the break, we'll talk about William Shatner being sued for $170 million for libel and defamation, and talk about where that case goes, how libel and slander work, and we'll do that after the break. This is Craig Ashton. The show is All Things Legal. Hey, we're back. This is Craig Ashton. The show is All Things Legal on Money 105.5, the Wall Street Business Network. This is where curious personal injury attorneys distill topical events into their legal essence. We are personal injury attorneys at Ashton Price, but guess what? We are curious, and every week we break down stories that you can read on the internet, Wall Street Journal, New York Times, New York Post.
hey.
Yeah, the New Yorker magazine.
It was on Yahoo, man.
So today is no different. So we got William Shatner. William Shatner sued for $170 million by a man claiming to be his biological son.
You know who should defend him? Danny Crane.
Yes, exactly.
From Boston Legal.
So here's the thing.
Shatner going in and out of character as he's interviewing himself. Yeah.
So Peter Sloan, apparently they didn't meet on the T.J. Hooker set.
They met on the set of T.J. Hooker. He was not conceived.
Right. In other words, he conceived during that.
Yes.
Okay, right. Good point. De minimis, but a good point nonetheless. So basically, William Shatner's not 80 years old. He's getting sued by a 59-year-old guy who says, hey, I want you to acknowledge me as your son. William Shatner says, look, I got some daughters. I don't have any sons. So Peter Sloan is saying that is a statement of fact of and concerning him, which ultimately is calling into question his reputation, which is causing him damages. So here's the thing.
Yeah.
This is how this goes nowhere. Because right now there is no fact that this individual is William Shatner's son. Correct. It's not a fact. It's an opinion.
Correct.
And because he may have slept together with Kathy McNeil during the time where the conception could have taken place, but I don't think that supposition is been risen to a level of a statement of fact. And the only way that it's a statement of fact is if William Shatner has a paternity test that factually says he is the father and he denies it. Then at that point, it may be defamation. At this point, it's an opinion, and opinions are protected. Plus, he's a public figure. So you have to have reckless disregard for the truth.
But even so, I mean, I think they've already done a request for a DNA test, and Shatner said no. I mean, why would he consent to that? That's ridiculous. I'm in William's corner.
No,
Danny Crane.
I agree. I agree 100%. In this, part of the problem is we're okay. Even if it is all true, what are his damages? What has he lost financially because he has no relationship with his? I mean,
he's much better off because William Shatner is actually a very rich individual now with everything he's done with Priceline. And let's say that William Shatner does not acknowledge him in his will or in his estate or in any way, shape, or form, or fails to put in a clause where he disregards any children that aren't named. Then he becomes a putative heir. It's I can't remember, man. I took that wills and trust class 25 years ago. An omitted heir, that's what it's called. So if he comes in as an omitted heir, then he would have then he would have his action for his intestate share. So,
he'd have to prove that he's the son, though.
I know, but they would be able to do a DNA test at that point.
And for those who don't understand the intellect of Ed Schade, intestate is what, Ed?
You die without a will, but he's probably had all that set up. But if you fail to include a child or omit that child, become an omitted heir, and despite what you say, then they can take what would have been their intestate share as if you died without a will. But you can't put a clause in your will saying,
I specifically indicate that Peter Sloan,
or not even him, anybody. You could say
anybody
not mentioned In my will,
Is
I am
intentionally
Right.
omitted.
Omitted.
Exactly, yeah.
And
You
you
would need
have
to
to
use
have
those
that.
words, intentionally omitted. Yeah, you'd have to be specific as possible.
So there's other, we just crossed into another field of law.
yes.
We just went where we've never gone before.
No man has gone before.
All right, that is a beautiful segue to getting into where we've never gone before with Donald Trump. We are now going into a realm whereby we are
The Republican
entertaining-
Party's
the
never
Republican-
gone
the Republican Party is entertaining, essentially as their nominee, Donald Trump. As you may or may not know, at $5, and this fact will give me a cup of coffee at Starbucks. But George Washington's my great uncle,
No.
whatever. So anyway, Donald Trump is not George Washington, all right? Donald Trump is, I don't know what.
He's not even his wooden teeth.
The guy says some things that I find interesting. Overall, I don't think he's good for our country. I like to travel, and he's limiting my options at this point. So Corey Lewandowski, who
Very
is
good.
his putative Polish campaign manager,
Yes.
grabbed the arm of Michelle Fields. At first, he denied it, and there's a videotape
It's on
of
film,
it.
yeah.
And the thing that I don't like about this is she basically went on her blog and said, quote, Trump acknowledged she was jolted backwards. Somebody grabbed her tightly by the arm and yanked me down. I almost fell to the ground, but was able to maintain my balance. I mean, that did not happen. And so she amplified the issues presented to basically get this guy arrested. And I think they arrested him before they saw this videotape. And a battery, which this is, which is the harmful or offensive touching, not only has to be harmful or offensive subjectively, because some people are, more thin-skinned than others.
Here's the actual statute.
Okay. The reasonable person standard is that a reasonable person has to find it harmful or offensive.
Correct. Like me coming to the office and say, "What's up, Craig?" and punch you in your shoulder.
Or how about I just dap you on
Right,
the,
exactly.
I give you a fist pump and you
Right.
go, "Oh, that's a battery." And people go, "Look,
Nobody would think that's a battery.
Yeah.
Exactly.
chill out there, Timmy FP."
Stop being so sensitive.
Yeah, Swaggy P. So the point is that when you see the video, the first thing you see is that she grabs towards Donald Trump's arm and he pulls away. So Donald Trump found that harmful or offensive. Apparently he's a germaphobe, so he doesn't like to be touched anyway.
Yes.
And then Corey Lewandowski saw that reaction from behind of Trump pulling away, reached up, grabbed her by the arm, and just pulled her backwards. Didn't almost pull her to the ground. She didn't even stumble. Just stopped her interaction with Donald Trump. So now a jury, which I think they'll probably do because Donald Trump will pay for the defense here.
Of course he would.
And a jury's going to have to determine, and in Florida it can be 6 people because they don't need 12. In Florida,
They're all Rubio fans. You never know.
yeah, it's true.
Little Marco might be on
Marco,
the.
yeah.
Exactly. In voir dire, how do you feel about little Marco?
I love him. You're off.
Exactly. So the point is, this guy could get the death penalty if this goes wrong.
Crazy things have happened in Florida, man.
Exactly. So the point is that a jury would have to determine that unanimously, and it only would have to be 6 in Florida, unless it's a capital case, and then it would have to be 12. But this isn't a capital case, unless, of course, it goes horribly wrong. So the point is that harmful or offensive touching has to be a reasonable person standard. Watching that video, my opinion is unbelievable waste of judicial resources
Yes.
to file a cause of action based upon a purported battery, which shows just a heated interaction within the confines of a crowd of people, and what to me appears to be a relatively reasonable interaction because of Donald Trump's response to this reporter grabbing him.
Not only a waste of judicial resources, it seems like an abuse of prosecutorial power. I mean, when you get to the DA's office, you have to go to the filing DA, and somebody brought this in, and they said, hey, does this deserve to be, the people proceed against this? And some DA over there, who was probably a little Marco fan, said, yes, it does. It absolutely
exactly.
does.
I mean, if you don't like
This could be
him-
politically charged.
Yeah.
Yeah, clearly. I mean, we referenced it a couple weeks ago. I mean, it's a much grander scale, but that the Duke rape case was politically charged. I mean, there's reasons DAs can bring cases if they can justify and they can prove the elements. I mean,
Well, the elements are, and I actually brought it up. It's 784.03, a battery, and it's 1A1. And what the Florida statute says, actually and intentionally touches, which he did here, another person against the will of the other. So, I mean,
so it's not even harmful or offensive in Florida. It's just against the will.
yeah, just against the will. It's not even harmful or offensive.
So she could say, I was doing my job, and against my because I was trying to be a reporter, and against my will, you moved me out of the way to do my job.
So in Florida, you can stand your ground and shoot somebody.
But you can't grab
But you
their
can't
arm
grab
and
a
move them out of-
reporter, or you're going to get charged with a crime.
And you better not. You better not show up on Christmas Eve or Black Friday and push somebody out of the way to get to the $2 microwave, because then you've done a bad.
Well, I mean, if that's the way it could be, just think of football games in Florida. How many times?
know-
What if when you're charging the court in a basketball game, you push people out of the way in Florida to get onto the court? I mean,
taxes are tough here in California, but we got Elon Musk, we got Facebook, we've got Intel, we've got kind of intellectual
exactly what it says.
movement towards, really good, I think, a political system. You may not always agree with it, but I mean, at least we seem like we think things out. And this is Florida again. What's going on there?
It does not say harmful, offensive. You're right, Ed. This is the actual statute.
All right, so we are.